You are an Oregon business owner, and your business has been severely disrupted by the coronavirus. Your business may be shut down. Your business may be limited. Maybe you applied for the Paycheck Protection Plan and got approved, but that's not enough, even if you did. Maybe you got denied, and that makes matters even worse. I'm Richard Rizk, and I work for insurance companies for 10 years. I know how to read policies, insurance policies, and I know how insurance companies operate. I'm here to give you some pointers on what to do in Oregon if you have business interruption and a business insurance policy. The first thing you do, get the rules of the game. Your policy is the rules of the game for how to present a business interruption claim. You wouldn't want to play Monopoly without knowing the rules of the game. Get the rules of the game. Now, there's policies and there's the real policy. The real policy is called a certified copy of your policy. That means somebody is going to sign an affidavit and swear that this is the real policy that you have. Because policies are made up of different forms, and it's very easy to make mistakes on the forms as to what makes up your true policy. So get that policy. Now you're going to read it, and it's going to look like Greek to you. Keep in mind, your policy was not written with the coronavirus in mind. It was written with all kinds of other risks in mind, maybe business interruption in general, but not the coronavirus. So it's probably not going to be clear from the terms of your policy whether you have coverage. Well, there's a rule in Oregon. If there's any ambiguity in the terms of your policy, the courts will construe that ambiguity in your favor. So don't stress about the terms of your policy. The main thing we want to do here is to help you cover the spaces on the roulette board. We want to make it so 6 months down the road, if you're still having problems with business, that you'll have perfected a claim with your own insurance company. So if you do have to sue them, you'll be able to get attorney fees and costs. So this is how you do it. You got to send your insurance company by fax or other ways that you can prove that they received it, something called a proof of loss. Now, proof of loss is very broadly defined under Oregon law. It's basically anything that could give the insurance company enough information to conduct a reasonable investigation. So describe the loss in this proof of loss. Give substantiating materials that back up your loss. And then send it certified mail or fax it, but make sure they get it. Put in big bold letters, proof of loss as a heading, so there's no question whether this is a proof of loss or not. Now, why is this important? Because when they get a proof of loss, when the insurance company gets a proof of loss, it starts the clock ticking. Once they have a proof of loss, they have 6 months, according to the statute ORS 742.061, which codifies a decision by the name of Dawkins. They have 6 months to make payment on that claim. If they don't make payment after 6 months of them having a proof of loss, and then you have to sue them over this loss, you have a claim for attorney fees and your costs in that case against your own insurance company. So what you need to do is send that proof of loss so you get the clock starts ticking. So 6 months down the road, if you have to sue them, you'll have a way to get your attorney fees and costs back. Now, I'm Richard Rizk. We don't do this, for making money. I have not made any money on this teaching people how to do a proof of loss. But I am available to answer your questions if you have any. And here's the information to contact me.